Ready.
Okay, the May 30th meeting of the Compliance and Amendments Committee is now in session. Victor, the first item, please.
First on the first item, roll call. Member Highland. Here. Highland present. Member Moss.
Here.
Moss present. Chair Kanada.
Here.
Kanada present. We have a quorum of the committee. There are no agenda changes that I know of at this time.
Okay, great.
I'd like to make public comment on item 1.
Okay.
I'm Peter Warfield, Executive Director of Library Users Association. I'm very glad that later in this meeting you are going to be discussing a landmark decision by the task force having to do with Ray Hartz's complaint against the library for not having an agreement with the Friends that says the Friends will comply with the Sunshine Ordinance. But that's not what your agenda says. In fact, 3 agendas in a row have completely misled the public as to what it is you're doing. Completely misled. Not to mention your attorney's letter, which talks about a webinar. Something I know about, because it was boilerplate from a completely different complaint. So here's what your agenda today says about what's happening. And let me read the last paragraph of 3 first, which is what you're going to do today. The Compliance and Amendments Committee shall hold a hearing on file numbers 17047 to 1. Determine if the Sun... Now, this is the wrong file number. We're talking on item 6, file number 16117. So here's what the Compliance and Amendments going to do today. Shall hold a hearing on file number 17047. To 1, determine if Sunshine Ordinance Task Force has jurisdiction. 2, review the merits of the complaints, and or 3, issue a report and or recommendation to the task force. The task force, upon receipt of the report and or recommendation from the committee, shall schedule and conduct a hearing on the merits of the complaint. Now, you've already had your hearing with Ray Hartz's complaint. So let me read you this. The first paragraph. Complaint filed by Ray Hartz against City Librarian Luis Herrera in the Public Library for allegedly violating Administrative Code Section 67.296 by failing to disclose the amount and source of all outside funds or services worth more than $100 in aggregate accepted by the Public Library for the purpose of carrying out or assisting a city function on their website. No. There was nothing about that issue in Mr. Hartz's complaint. Nothing at all. His entire complaint, which was very short, had only to do with the fact that the library does not have a written document from the Friends saying they will comply with the Sunshine Ordinance. And if you'd like me to read what his complaint is, it's incredibly short and very simple. So this is completely confusing, completely misleading. I am very interested. I have had trouble following what's going on, what's the status, what is happening today. It's complete confusion and misleading, and I think it's highly inappropriate, at least not to clarify what's going on here. If not, stop today and do it another time the right way. Thank you.
Any additional public comment? Seeing none?
Next on the agenda, item number 2.
Hold on a second. I feel like. I mean, there is a agenda error, though, is that probably should get moved to that section, though, or at least clarified. Sorry, I think my mic's not on. I mean, if we're still on section 1 for agenda changes, then I think that maybe it's appropriate to at least look at one of the issues that he just raised is that the section for number 17047 was misplaced in
that is
that
incorrect.
section.
17047 is on the agenda as item number 7.
Right. So the section that he read from that is under 6 actually belongs under number 7.
No.
No.
6 is correctly placed.
So, okay. So the way that you formatted, just so I understand, we can clarify, the section that starts, the Compliance and Amendments Committee shall hold a hearing on file number 17047. That is applying to the number directly below it, not
Yes.
the section above it. Okay, I believe that is probably where Mr. Hartsfield was the confusion in the first part of his comment. Okay, I feel like I've clarified that. Thanks.
Okay.
Did Mr. Hartz and Mr. Warfield get married? Is it Mr. Hartfield? No, never mind.
I'm sorry, Mr. Warfield. It's been a while. My apologies.
That's okay.
My
All right.
apologies.
So, that's
The
Mr. Hart.
number is a minor point. The wording of the whole thing, including the one right under the item number, is still completely wrong. There isn't even an overlap in your wording relating it to the actual complaint.
All right.
Okay. Let's go to the next item.
Next on the agenda, item number 2, approval of the March 13, 2017 Compliance and Amendments Committee meeting minutes.
Sure.
Yes.
So under item 2 of the minutes, I noticed that it has member Hinsey seconding a motion, and I don't believe member Hinsey. I think that was member Highland at that point.
I will make that change.
Anything else?
No, that was it.
Okay. Do we need a motion to approve and then public comment?
I think we can accept without.
Okay.
Motion made by member Moss, seconded by member Highland, to adopt the minutes as amended.
Any public comment on the minutes?
Peter Warfield, Executive Director of Library Users Association. In the first place, I didn't understand what the change is. What I did notice is that member Hinsey, it says on item 1, was appointed to serve on the Compliance and Amendments Committee in place of member Highland for the January 9 meeting. I didn't understand what the thing was with Highland and Hinsey.
That may be a misplaced remark.
Pardon?
He said that might be a misplaced remark. I don't want to interrupt your public comment.
I just wasn't clear whether Hinsey replaced Highland for this meeting, and it looks like it was a prior meeting. But I'm not sure why
So can I?
this replacement is noted in the call to order for the meeting of March 13th.
I do see the addition. Sorry. At your discretion, maybe we should delay these until the next meeting and we can make corrections and bring it back for your review.
Well, I think the correction was that under item 2 of the minutes, it says member Moss seconded by member Hinsey. And member Hinsey wasn't at the March meeting. She was at the February meeting. So the correction was instead of seconded by member Hinsey, it was seconded by member Highland.
And then Mr. Warfield has pointed out that in section 1, there seems to be a line that has carried over from a previous agenda.
Right.
That's what I'm imagining what happened. And so we need to strike that line that says member Hinsey was appointed to serve on the Compliance Amendments Committee in place of member Highland for January 9th, 2017 meeting. I think
Correct.
that's the issue of confusion. So if I can amend my motion to strike both the final sentence of item 1, that is member Hinsey was appointed to serve, as well as change member Hinsey to member Highland in number 2. Is that sufficient?
Accepted as amended.
So then all of the other references to member Highland in the rest of the minutes are Mr. Highland because that's the date of that meeting.
Correct.
Thank you for that. And I wanted to compliment member Moss and the committee for the item 10, where you say that member Moss, seconded by member Highland, moved to submit a request for public records to the city librarian Luis Herrera and the public library, requesting all records, emails, advice, letter, correspondence, and other documents regarding contracts/agreements with the Friends of the Public, presumably public library. You might want to correct that. Required by Sunshine Ordinance, Section 67.29-6 for the period 1999 to the present. and to submit a request for public records to the Office of the City Attorney, requesting any records related to advice provided to city departments regarding Sunshine Ordinance Section 67.29-6. I was very happy to see that, and didn't really understand whether that actually happened because the material that's been attached I didn't see the request to the city attorney, so I was a little bit unclear whether that actually happened or whether this item is misstated and it was just a request to the library. So maybe it's correct the way it stands. I just didn't see a request letter sent to the city attorney in the 196 pages having to do with that item later on in your agenda. So that's
Thank
a
you.
question, really, but it might be a correction as well.
Is it okay if I answer you real quick?
Please.
Yeah, so
Please.
it's on the city attorney one is on page 209.
Thank you very much. You might want to put library, public, where you left out library, you might want to add that. Thank you.
Thank you. Any other public comment on the minutes of the last meeting? Yeah. Can you hear me now? Or is, hello, hello, hello? Can we put these louder, Victor?
That's as much as
Okay. Can you hear now? Okay, good. So any other public comment on the minutes? On what? On the minutes of the March meeting? No. Seeing none, can we
on that motion to
approve by...
approve the minutes as amended. Member Highland.
Aye.
Highland, aye. Member Moss.
Aye.
Moss, aye. Chair Kanata.
Aye.
Kanata, aye. The motion passes. Next on the agenda is item number 3, public comment. Members of the public may address the committee on matters that are within the committee's jurisdiction but not on today's agenda.
And 3 minutes each.
Yes.
General public comment. Do we have any public comment?
Of course.
I'm not even sure if I'm at the right meeting. This is just the first thing that was on the schedule for me to come down. I came home today to find out that there's no parking on my street anymore. There was no 72-hour notice. There was no information provided to any of the residents. All of a sudden, we've got signs and red curves. I called up 3-1. You can't hear me?
It's for the record.
Okay. I believe the city should provide us with some information, give us a heads up, and possibly even give us an option as to where we're supposed to park. I live south of Market, and when more than 20 spots are taken away from a small area with no notice, we're putting our residents where? I'm an electrical contractor. I need to move tools. I need to move materials. I have elderly people living across the street. They need their cars for shopping, for going to the doctor. We need our vehicles. By taking away all the parking in our area, what you're doing is you're forcing people who work and live in San Francisco out of San Francisco. How many Bay Bridges can we build? Where's the infrastructure to support more people commuting in and commuting out every day? Can you tell me, how do we get this fixed? No comment.
Let's conclude public comment, and then we can,
Yeah.
if you would like to provide a response.
Okay, this is not the venue for that issue. I
Through the chair. The way this works is you state your piece, and after all the public comment's done, we can maybe try and address it, but it's not a back and forth exchange. That's not the format of this meeting. So
Okay.
we've noted, and we'll get to you once everyone else has had their say as well.
Thank you.
You're welcome.
Peter Warfield, Executive Director of Library Users Association. I do expect to comment on the substance of the Rayhart's complaint later when it does come up. But my comment now is to recapitulate that your agendas have been highly misleading every time that this matter came up at the EOT, the Education Outreach and Training Committee, the full task force, and on today's agenda. And in such a way that it made a muddle out of what the complaint really was about, and I think really interfered, it certainly did with me, interfered with a person who has an interest, understanding what the matter is about. It also muddled tremendously what the materials were, the answers provided, the materials provided, and so on. And now I'd like to comment on the letter, the completely screwed up letter from the city attorney, who is giving you very poor support on other issues as well, including our complaints and other complaints. In the second paragraph, let me read the complaint. It's pretty simple. From Ray Hartz on page P192, City Librarian Luis Herrera, a city department head, has a, quote, allowed to be collected, unquote, funds for the purpose of, quote, carrying out or assisting any city function, unquote, without putting in place...
Point of order. This is on an item that is on today's agenda, so please keep your remarks to general public
Okay,
comment.
I'd like to take my direction from the chair and not from a member.
I can make a point of order, so that is the point of order.
What does the chair say?
This is an item on the agenda, and general public comment is for items not on the agenda that have to deal with the work of the task force.
All right. Then let me say this. This is just an example of your city attorney giving you extremely poor support. Your city attorney has used boilerplate and completely misconstrued the nature of complaints that this Sunshine Ordinance Task Force has gotten in the past. In the past, there have been misapprehensions of what the complaint was. There have been misapprehensions about what the law was, that what questions should be asked, and I'd be very happy, if you like, on another occasion, to give you a few really, what I would consider shocking examples. Now, to give some sympathy to your city attorney, it's my impression that he has very little time to prepare the opinion letters that your committee and that your body get. So that certainly could contribute to these incomprehensible and otherwise incompetent letters. And when he asks questions, there have been times when they've been very biased against the complainant, and at other times just simply irrelevant to the actual complaint. And I think it's a serious issue. When I saw this agenda, it rang in my mind the reminder about these bad letters. Thank you.
Members, Ray Hartz, Director, San Francisco Open Government. I'd like to say I agree with Mr. Warfield in the sense that almost every complaint I've had through the task force, when you read the city attorney's advice, there's something in there that has absolutely nothing to do with the case. It may mention a person that has, no relation to the case or questions in the law. And honestly, the questions that he poses for your consideration are typically biased in favor of the city agency and against the person filing the complaint. I've spent 8-9 years now putting in Sunshine Ordinance complaints, and as much as the library and others would like people to believe that I'm just a crotchety old man that has nothing better to do with my time, I'm somebody different in the sense that when I read on the back of your agenda and every other agenda in this city, know your rights under the Sunshine Ordinance, I actually do. And when I go into a city body the very first time, I tell them I'm here for two primary reasons. One is to ensure that if any member of the public wants to make a public comment, they're able to do so without being interfered with. And number two, if they want to get public records, they can get those public records without being interfered with. And as much as they would like you to believe that I'm just a crotchety old man, the bottom line is the difference between me and a lot of other people who get the same treatment is that I have taken the time to document all of it. I now have 33 orders of determination where various city agencies and bodies, including the library and the Library Commission with 9 orders against them, and the Board of Supervisors with 9 orders against them, that show that the right to free speech in this city is not being respected. And you can go back and you can say, well, that's just your opinion, Mr. No, it isn't. It's the opinion of the task force by issuing 33 orders of determination where they have determined that various city agencies, commissions, boards, or whatever have violated the ordinance in my particular cases. And I'm not paranoid. I'm not delusional, so I don't think they're just out to get me. I think they just don't want to answer certain questions. And when it comes down to it, like the library, 9 orders. And what has the Library Commission done? They haven't even discussed it. So when Ms. Blackman comes here and represents herself as representing the Library Commission, how can she do that when the Library Commission has never discussed these orders? The only thing she can really honestly say is that she's coming here putting up whatever case she's been told to put up with, primarily by city librarian Luis Herrera, who, from my perspective, is the most dishonest person I know in city government. And you can look at the FPPC findings that he lied for years, accepting thousands of dollars of gifts from the Friends and then declaring under penalty of perjury that he didn't get anything, which is the very reason those forms are filed, to determine conflicts of interest. And if you lie about getting the money, it's hard to see the conflict.
Any other public comment? Seeing none, Member Highland, do you want to address the first issue?
Sure. Through the chair. Please approach. Victor, you might be able to help us out here, too. This might be something for Board of Supervisors or specifically for a department, if you want to weigh in on where this gentleman might go.
My understanding is you contacted 311. And
I did.
They did not give you adequate information.
The guy was more sympathetic. He also lives in the U District parking, and he also recently just lost all of their parking out of nowhere. He filed my complaint with the MTA. I am to expect in 21 days to get some sort of a response from them. That's not quite urgent enough. And if I need to go to the Board of Supervisors, and thanks, and this is my first stop because you guys just happen to be having a meeting today. And so I came on down here to talk to you. And if I have to go to the Board of Supervisors, then that's what I do.
Asking for records related to his
Sure. So the clerks can give you some advice. I would also go to your supervisor. Is it Jane Kim in your?
Yeah.
Okay. Get a community letter going to her, identifying this, and have her run with it as well. She's very responsive.
I hope so.
Yeah.
This is a bad problem.
Sounds like it. Yeah.
Not that the rest of them aren't bad. But
yeah. And at the same time, the clerk's going to suggest that you can. Start an IDR, and he can explain what that is.
You can submit an immediate disclosure request directly to the SFMTA. They have a public records request form on their website.
Okay.
And you can request records related to your question and or problem.
Yeah.
But please be sure to ask for records and not ask them a question.
Okay. And as far as I can tell, no one was aware that they were going to do this. I spoke to a number of my neighbors. Of course, they're all out on the street. They're all up in arms. Mm-hmm. And this was a surprise to us all.
Yeah.
Feel free to contact me tomorrow, and I can help you further.
How do I contact you?
You can call the main office at 415-5. I'll write it down for you once we get the meeting started.
All right.
I'll come and see you in a moment.
All right.
Okay.
You're welcome.
Any additional public comment? Okay, seeing none. Next item, please.
Next on the agenda is item number 4. File number 16092, hearing on the status of the order of determination, complaint filed by Anonymous against Dr. Lydia Young, Department of Public Health, for violating Administrative Code, Section 67.25, by failing to respond to immediate disclosure request in a timely and or complete manner. Task Force referred this matter to the committee with the request to provide all communications documents related to the Family Health Center Patient Advisory Committee for the period of January 1st, 2014 through September 18th, 2016. It is my understanding that the respondent has provided all records that they have, and I have mailed a copy to the respondent.
To the complainant?
To the complainant, yes. Sorry, my apologies.
So is the complainant here? So have you received the documents that Victor sent?
Well, I believe there's probably one missing. I appreciate that I have received actually, it gets a little complicated. I've received a packet of documents. But I have a complaint about the way this was done. I'm holding here in front of me 2 envelopes, one with a postmark of April 7th, and the other one with a postmark of May 24th. The May 24th, I just picked up my post up from my post up in the last 2 hours. The other one, which came, I believe both of these came from Mr. Young. And the first one came only because I was inquiring or prodding him to send documents. They were not sent directly to me, and I don't understand why not. I believe that they were sent in both cases to Mr. Young, but that's one issue. Maybe we should deal with one issue at a time.
But you did get the documents.
I did get what I believe to be most of the documents. I still believe there's one missing.
What is that one document?
That's missing?
Yes.
Well, I attended a meeting in 2014, and of this group, this body, this patient advisory committee of the Family Health Center, and I don't believe there's any agenda item in the packet for that date. I don't have the date with me, but I looked through the documents. I don't see my name anywhere. So I was at the meeting. I know that for a fact, and I know I even have notes with Miss Angel's name on them and her phone number, and at least one member of the body. So whether we want to proceed, we say that whether the compliance is complete. I don't believe it's complete, but we've made a lot of progress, although I am very frustrated. It took I think it took at least 6 months to get this far. Again, compared to the last hearing, which I attended with a representative from the Family Health Center, where they refused to produce any documents that addressed the crucial question of agenda. I mean, the agenda is the agendas of their meetings. We've made enormous progress. There are copies of look like bona fide contemporaneous agendas of meetings that have happened in the 2-year period I requested.
Okay.
Whether you could hold this over for a missing document is probably up to you, I suppose.
Can we hear from the respondents?
Sure.
Thank you.
But I also want to know why I only got the first batch. These seem to be duplicates, okay? These seem to be duplicates. I don't know whether it's appropriate for me to ask Mr. Young if he knows if they're duplicates or not.
Pursuant to the emails provided by the department, they provided the first set of documents from what they had at the time, and then they provided everything again with additional documents prior to this meeting.
Okay. And
Okay.
just to you, not to...
She did indicate that she provided directly to Anonymous.
Well, she didn't.
Okay. Can we have the respondent up and...
But, okay.
Hi, good evening.
So before you start, there's two questions I have.
Questions.
Were the documents mailed to the complainant and to the clerk?
I emailed them to Victor,
And how
it
about-
was mailed. Yeah, I went to a PO box. I believe that I had from an original. I believe actually it was a first complaint, but
Okay.
I don't know. I
okay.
can make a.
And then just as to documents, as to any documents from the 2014 meeting that was referred to.
Yeah, we provided all the documents that we had. I actually do believe there should be a document. It was an agenda. I'm trying to look for the. I don't believe names were listed. We don't usually provide names. It was, I believe, in March 2014. I don't have a copy of the file. I apologize.
Okay. Victor, do we have the documents in the?
It's in the packet. The entirety of the submission is in today's packet.
Have you been able to find anything?
I mean,
March?
there's various agendas in here for 2014 and 2015. So for 2014, I see November 25th, 2014. I see June 24th, 2014. I see April 22nd, 2014.
And what pages are you on?
Possibly the 20.
So these all start on page 28.
Or
And
April?
there, on page 28, there's what seems to have been an index created by. Is this created by you?
Yeah, so after the last meeting, it was recommended that I brought the documents that we had collected up to that point, and it was recommended that we create some sort of table of contents with that, and that's what I did.
So
with the-
February and March 2014 may have had meetings, but there weren't records available, and the same goes for May 2014 and September, October 2014.
Okay.
That's if I'm reading that correctly. Yeah.
Okay.
Yeah, we provided all the documents we had available to us at this.
Okay. So the complainant, please come up again. So the question of P.O. Box, is your P.O. Box the same as it was when this was original, when your complaint was first filed? Or, because the respondent's saying they did mail.
Was it returned?
I didn't. I do have to say there has been moved offices, so I don't know if there's any return. We have moved offices, but I sent it.
I did make a correction in the post office box, which I know Mr. Young was aware of within the last 2 years. It is possible that they sent it to the original, which has a slightly different one digit. There's some, you know what? The post office is supposed to honor both numbers. The one that I had actually for 40 years, and the one that these came to in the last 2 months, but they have made mistakes in the past.
I mean, it seems like they went and fulfilled what was asked of them. So, okay, so.
But I want to make one more. I'm going to repeat what I said before. Apparently,
Would you like to allow them to have 3 minutes each for a final statement prior to
Yeah,
the motion?
if you want to make a final statement, go ahead.
well, I am concerned because for all I could tell, the respondent sent the documents to Mr. Young, not to me. That's my knowledge. I mean, my knowledge is that the documents were sent to Mr. Young, not to me, and I think this may have happened once before with another complaint. For some reason, they weren't sending it to the complainant, but to Mr. Young. And I had to get him from Mr. Young, and I don't think that's the way the law is supposed to work. If I make a request for a document, it should be sent to me. Mr. Young is an administrator and a go-between, I don't think that's one of his jobs, which is to forward documents to the complainant. If there is I believe, okay, is it feasible if I have not looked through every single one of these, especially since they appear to be a duplicate set. If I find that this all started because I knew firsthand that I went to a meeting of this body, all right? I could swear that I was there. They had produced no document to that effect. I still would be happy, and this all has to do with their keeping proper records of their meetings, their agendas. That's overwhelmingly, I think, the sunshine issue here. I would prefer, if we could do it, to make sure that to find out for sure whether or not they actually kept a record of that meeting. I think you may have given the address, the date, which was March of 2014. I think we would be finishing this job thoroughly and completely if we knew for sure that was missing, and that's probably a violation. And that would be my final statement, I guess.
The respondent, anything else?
No, just that I think our department has tried our best to provide every document that is asked. If there's any questions, I'm here. So we're not trying to
Thank you.
not provide anything. Thank you.
Members.
I mean, it seems the issue before us is only a records-based one, not one that is about whether they were maintaining agendas properly or that their agendas were properly formatted or any of those things, which could be a whole separate issue on its own, but that's not what's before us today. It's whether they have complied with the public records request.
I seem to remember that out of the full committee, we discussed that, and I think as a result of this case, this department has now started to keep those agendas moving forward, so they can't go back and produce what was never created 3 years ago. I think they've satisfied what was required of this particular request, and
Right, and I do see that for 3 of the meetings, the March of 14 one also on page 28 of this packet, where they have the spreadsheet of all the meetings, that 3 meetings they don't have any information about. So that there would be nothing from the March meeting there. So I mean, I would think that they've complied with what was asked for, and if there are other issues, the complainant can file, another request and or another complaint.
right. So I'll make a motion to close this item.
I'll second it.
Okay.
The motion is to find that the respondent has complied with the order of determination and to conclude the matter.
Correct. So public comment. Any public comment on this item? Seeing none, let's have a vote.
On that motion, Member Hyland.
Aye.
Hyland, aye. Member Moss.
Aye.
Moss, aye. Chair Kanata.
Aye.
Kanata, aye. The motion passes. Next on the agenda, item number 5, file number 16109, hearing on the status of the order of determination, complaint filed by Mike Black against Animal Care and Control for violating Administrative Code, Section 67.21D and 67.24I by failing to respond to a records request in a timely and complete manner and withholding records and not citing an appropriate provision of the Sunshine Ordinance. On February 1st, 2017, the task force heard the matter and found a violation of the Sunshine Ordinance, requested that the respondent provide records related to the city dog lease laws for the period of January 1st, 2014 through February 1st, 2016, and referred the matter to the Compliance and Amendments Committee. There has been communications between the parties and documents have changed hands regarding this issue.
Okay. Mr. Black?
Good afternoon. I'm Mike Black, the complainant. It's been almost exactly 16 months since my February 1st, 2016 public records request, which is the subject of this hearing, and almost 7 months since I had to file this complaint with the Sunshine Ordinance Task Force about the response I was getting from Animal Care and Control. With responsive records still being discovered at ACC as late as May 2017, it's clear I have yet to be provided all the responsive records ACC should have. I will just briefly mention here again the missing statements of decision from the vicious and dangerous dog hearings, the responses to the specific emails I cited at the March 13th hearing of this committee, and other references in the records I was provided, like see attached email, see file such and such, which indicate the existence of records I was not provided. But I think the time has come to move on to other public records that I need to obtain from ACC without in any way conceding that the response from ACC to my initial records request has been satisfactory or complete. I originally sought records in an attempt to understand how ACC does and does not enforce San Francisco's dog leash law. And now that my sister Carol Summers and I have decided to make a documentary about ACC's failure to enforce dog control laws in the city, a broader range of documents need to be obtained, such as records of registered vicious and dangerous dogs, and soon the records of all dog bites in the city. Records, unfortunately, that the law requires animal care and control to keep. I say unfortunately, in just the past 2 weeks, and in spite of 4 hearings before this task force, I've still had trouble getting ACC and its custodian of records to comply with the Sunshine Ordinance, as documented in emails to the task force. I fear it's going to be a long, rough road ahead, and I'll need to focus on that for now. So let me just end here by saying that I'm really, really, truly grateful that there is such a thing as the Sunshine Ordinance Task Force. While I do not think the task force has always done and said the right thing in my case, and seeing that its power to do much of anything is pretty limited, it's nonetheless obvious to me that I would never have gotten all the records I've gotten without an oversight commission such as this one. And with the ongoing efforts to improve the Sunshine Ordinance and the work of the task force, I'm optimistic that the public's access to public records will be even better served in the future by changes in the law and in the way this commission operates. In particular, I urge everybody here to support the hiring of independent legal counsel for the task force, separate from the city attorney's office. And everybody can also contact their state representatives and urge them to support Assembly Bill 1479, which for the first time institutes penalties for failing to comply with the California Public Records Act. Public records are our records. Thank you very much.
Thank you. Is the respondent here?
I'm Diana Christensen with Animal Care and Control.
So for the original request, Mr. Black says there are still certain documents missing. What is the status on those?
I think Mr. Black is making assumptions about what exists versus what should exist versus what doesn't exist. I've done a search for the records that he has assumed have been there. I've, in fact, found other records that were never given to him and provided them to him, but I didn't find, for instance, responses by the organization to the 6 complaints that he had brought up at the last meeting. I don't know whether there were no responses, whether those responses were destroyed, or what happened to them. I simply don't know. I know that the organization for the first half of 2014, I believe, doesn't have copies of the vicious and dangerous dog decisions on site at ACC or in its electronic system. I can't provide what we don't have.
Okay.
We have given thousands and thousands of documents related to this request.
When you say that you don't, would they be somewhere else? These dangerous dogs decisions?
The vicious and dangerous dog process is shared by the police department and by ACC. So presumably, the police department generally has maintained the investigation case. So yes, they may be there. They may also be with the contractor who wrote the decisions.
Who is the contractor? Like, is there
John Denny?
But isn't it the ACC's responsibility to go to the police or point the complainant at specifically where to go to find these records that you are supposed to have but don't? And I'm asking this now more for the future also. These are significant public records, especially when you're getting into dog bites and things like that, where it can be dangerous for the general public.
Certainly, the vicious and dangerous dog hearings are a major piece. The other responses, I don't think apply to that. But in terms of the vicious and dangerous dog decisions, I think Mr. Black is aware of the relationship between the SFPD and their investigator and John Denny. He is videotaping that process, and it didn't occur to me that I should inform him of what it's apparent he knows.
Mr. Black, could you approach again? Am I to take it from your presentation that you're okay with us closing this one today? Is that to move on?
I think I have to be, and again, because number one, I don't want to quarrel over every single record. That as you know, it can be very difficult to prove that there should be a document there. Probably there is, but how can you know? You just can't always know. So I don't want to. I have other things to do in this with animal care and control. So it's for me. It's just a more efficient thing not to go forward with this. But I don't want the record to reflect that I was satisfied or I thought I got a complete response.
I think that's fair enough, right?
But I'm certainly yes. I'm fine with closing the matter. But you will see me again, I'm afraid. Yeah.
So I guess in that case, should I make a motion at this point to close out this case, or are we able to make a note, Victor? Are we able to make a note in this that what was said here, that Mr. Black does not object to us closing it, but that is not conceding that he had gotten all the records that he wanted? Is that something we can make?
That is not a problem to insert into the minutes. But may I ask, why are you going to find that the ACC has complied with the order of determination?
I wasn't going to necessarily say that, but
I would contest that.
Yeah. Can it be closed without making that finding?
And the complainant can withdraw with that statement, and it'll be out of our hands. Somehow we must conclude the matter.
Right. The way it seems now, Mr. Black, is that from your statement, it's very difficult to prove what should be there,
right,
if we don't know that it's there. If the respondents say that they have no further data for this issue, there's really nothing else that can be done by us.
Well,
at this point in time,
to some extent, I could, as I said, there are files. Number one, there are missing statements of decision, not just from the first 6 months of 2014. The other thing, as I said, there are indications in the records I've received, like see attached email, see file such and such with a number and stuff, and I haven't demanded those at this point. I don't want to have to go back and wrestle over every single document, and this process of 16 months has proven to me that's exactly what lies ahead if I try to contest further the responsive documents to this particular request. I fear I'm going to be doing that already with other requests.
Okay. So how do we close this?
I'm not fully sure what our options are. Victor, what in the past, what are the various flavors of closing one of these that have happened?
This matter is sent to us to determine if the order of determination has been complied with. The usual method is to find that compliance has occurred and to conclude the matter. I don't know if it's a possibility to find that you do not believe that compliance has occurred and to conclude it. that's something that it's your decision to make. The complainant could withdraw it with the provision that he does not agree. He does not believe that they have provided all the requested information.
I'm willing to do that, because you're saying that I can withdraw, but without conceding that I've gotten a complete and satisfactory response.
So the confusion with me is that if he withdraws it, I mean, there's already been a violation issued. Like
Violation would, I believe the violation would stand. It's just that
we could modify that and state that he is no longer wishing to pursue the matter further, and he wishes to conclude the matter without further action by the task force.
But that's
with
certainly
the provision that he does not agree.
And that I'm just following up on what you gentlemen just said, and that does not somehow eviscerate the finding that there were violations.
I think that I think part of the issue here is that, when a complainant may want to not just have to deal with us anymore, and they're happy to move on, but they don't want to concede their legal right to take it to court later on if, say, a document shows up that, in further research there is something that did not come to light here. I think that is what we're trying to get at here.
May I suggest, off the top of my head, that the committee makes a motion to conclude the matter without providing a decision regarding the order of determination at the request of the complainant, who does not believe that all the documents have been received.
I mean, that's the motion I thought I made to begin with.
This is a roundabout, so.
Yeah, that's fine.
That strikes me as a very good compromise from my standpoint.
that is the motion.
That is the motion.
Thank you.
Is there a second?
That was my motion.
Second.
Would you like to allow summaries by the parties or public comment at this time?
I think public comment. Any public comment?
Ray Hartz, Director, San Francisco Open Government. I think there's always a confusion about the order of determination and the compliance. Bottom line is, if there's an order of determination issued, it is normally because a violation was found. And if they come back and say, well, gee, now they've given me the documents or they've complied, that doesn't make the violation go away. The violation still occurred, and they have just now corrected their mistake, or not, depending on the circumstance. So it's like me. I have 33 orders of determination, and each of those is, in most cases, multiple violations of the ordinance. And so I have, I hear complaints about, the Sunshine Task Force, you have to go to all these hearings. I have 33 orders. Each one of those had 3 separate hearings at a minimum. That's almost 100 hearings I've had to attend, and that doesn't count the ones that I didn't win and didn't file. So basically, I have no sympathy at all for the agencies who want to come in here and kvetch about how much time it takes up to comply with public records requests. It's their duty under the law. It is their duty under the law to allow public comment. And when they interfere with public comment or they fail to comply with the orders of requests from the public to give public records, they're in the wrong. And when the order's found, they're still in the wrong. It gives them an opportunity to correct it, which hopefully they will do. Unfortunately, in some cases, they won't even do that. I had one public records request for the library that they dragged out for 2 full years, and I appealed twice to the city attorney, the city controller of records, and it took them 2 years. And those were the documents that we finally used to take Mr. Herrera, the city librarian, to the FPPC in Sacramento. So I can understand Mr. Herrera not wanting to comply with the law. He doesn't want to give us documents that showed he violated the law. And he's the city librarian. That's why I find Mr. Herrera so offensive. He is a librarian. And my history with libraries is long and extensive, and I am used to dealing with librarians who are open and transparent and do everything they can in their power because it's their job to help you find things, not somebody who does his best to hide from the public records, to interfere with their ability to make public comment.
Any other public comment?
Good afternoon, Sunshine Ordinance Task Force. Louis Dillon for Making San Francisco Great Again Coalition. I'd like to reiterate Mike Black's comments that at some point we need to have more teeth involved in compliance of these violations. And, it's pretty clear that these are forms of theft or robbery from the public when you deny them the clear information and records that they should provide doing a public service. Part of any agency is to comply with the government's way of doing things, which includes the Brown Act and the Sunshine Ordinance, so that we have a clear and definite understanding of what's going on. I don't know, is there two Sunshine Ordinance task forces? Because I've been here before and I've seen completely different people. And now I just see you three, so are you split? How does that work? Anyway, what I'd like to say is that in this item number 5, it says records related to the city's dog lease laws. I'm presuming that should read leash, not lease, because as far as I know, the city is not involved in leasing dogs. So if you go further down the page, you'll see file number 17047. Above that talks about compliance and amendments.
Point of order, where your comments are subject to the motion that we're discussing, not other items on the agenda.
Right. Well, what I'm...
So please keep it to item 5.
It is regarding item 5. Item 5, I'm explaining to you that on your agenda page, you have typographical misspelt words, and that is carried on throughout this. I don't know who's putting this together, the agenda hearing, but the next item has something related to the item following it. And so confusion is, opposite to shedding light on something. And this committee here is supposed to shed light on violations, and yet they're really not on the same page as the violations. They're misprinting words, and they're also confusing members of the public with these paragraphs in the wrong place. Thank you.
Any other public comment? Seeing none, let's go to vote.
On the motion, Member Highland.
Aye.
Highland, aye. Member Moss.
Aye.
Moss, aye. Chair Kanada.
Aye.
Kanada, aye. The motion passes.
Okay, next item.
Next on the agenda, item number 6, file number 16117, hearing on the status of the order of determination. Complaint filed by Ray Hartz against City Librarian Luis Herrera and the Public Library for allegedly violating Administrative Code Section 67.29-6 by failing to disclose the amount and source of all outside funds or services worth more than $100 in aggregate accepted by the Public Library for the purpose of carrying out or assisting any city function on their website. On March 1st, 2017, the Sunshine Ordinance Task Force heard the matter, found violations of Sunshine Ordinance, referred the matter to the Compliance Amendments Committee to review the draft memorandum of understanding between the Public Library and the Friends of the Public Library to ensure that that Administrative Code Section 67.29-6 has been addressed.
Mr. Hartz?
Ray Hartz, Director, San Francisco Open Government. Two basic issues. If you look on page 191, the actual order of determination, it says Vice Chair Highland, seconded by Member Kanata, moved to find that City Librarian and the Public Library violated the Administrative Code by failing to maintain a written agreement to abide by the Sunshine Ordinance with entities collecting and maintaining funds, so forth. In your packet is this agreement, and in this agreement, it's not acceptable because it only agrees to comply with one section of the ordinance. And Bruce Wolf at the hearing made it clear to both the Friends and the Library that the agreement and the reading in this order of determination is that they comply with the entire ordinance, not just one section of it. So this is not acceptable in the sense that it's only saying they'll comply with 67.26. Now, another thing I'd like to point out is if you look at your documents, you're going to see a chart like this, but I'm going to look at one on page 557. And if you look down at the bottom here, it shows the actual amount given by the Friends that is authorized to be accepted by the library is $410,000. And you have a copy of what I'm going to show you next for a different year, but this is the same year as the previous document. And if you look at that, their gift of $400,000, if you look at the amount they raised that year, that's 11.46% of what they raised in the year. And if you look at what they actually spent, they spent over $4 million, and the $400,000 is about 10% of what they gave. So if the Friends are going to get up here and tell you, oh, this is a really good deal for the library, getting 10 cents on a dollar is not a good deal. If you go to the website for the library, right here at the bottom, you will see a link to the Friends website. And if you go to the Friends website, what they do is they start to talk about things like membership. And if you look at the fact that only 10% of what you give to the Friends goes to the library, that means if I buy an annual basic membership of $60, $54 of that goes to support the Friends and $6 goes to support the library. And I don't think anybody likes it when the money they're giving, thinking that it's going to the library, is actually going to the Friends. In fact, think about it. If you leave a bequest in your will of $10,000, that statistic simply means that $9,000 of the dollars you leave doesn't benefit the library, it benefits the Friends. And the library gets $1,000. And I don't think any member of the public seeing an endorsement on the public library's website understands that only 10% or less of what they're giving to the Friends is actually going to the library.
Thank you. The respondent, please.
Good evening, Sunshine Ordinance Task Force members of the Compliance and Amendments Committee. My name is Michael Lambert. I'm the Deputy City Librarian here to represent the library.
Okay. So the agreement that was produced, what page is that in our packet? Do we know?
It's on page 40. Oh, sorry, not page 40. That's my page 40. It is on
257.
Thank you.
I have some hard copies if you'd like one.
Yeah, please.
And while we're reading this, if you just want to give us the history of this document, like at the full committee, you guys said you were working on this. How long has this document been in production? When did this first?
Well, I'll just say that the library has taken this matter very seriously since the original complaint on December 20th. Our CFO, Maureen Singleton, I believe she was here in March, and she has been taking the lead on working through this agreement. And she was here. She stated the library's intention to come into compliance with the admin code. We've been working since December, I would say, with the Office of the City Attorney to understand this section of the admin code, but more importantly, to reach an agreement, a written agreement with the Friends of the San Francisco Public Library. I'm pleased to report We have secured this written agreement with the Friends of the San Francisco Public Library, signed by their executive director, dated April 26th. So we've been working for several months.
I don't see any signatures from the library on here.
Well, this particular agreement, you're right. It's just a statement from the Friends that they are agreeing to comply. This is in addition to a more expansive MOU agreement in which the library reinforces our own adherence to the city's admin code requirements as well.
And when is that memorandum of understanding supposedly going to be finished?
We can have that for the full Sunshine Ordinance Task Force. I imagine there's going to be another hearing following this.
So,
I mean, I remember when this came. I remember when this came through the task force, and I do read. I mean, the language of the ordinance says, when such funds are provided or managed by an entity and not an individual, that entity must agree in writing to abide by this ordinance. And it doesn't say to abide by this section. And the agreement that we're looking at here is talking about abiding by this section and not by the Sunshine Ordinance. Now, if the authors of the Sunshine Ordinance made a mistake there and they meant to say section, the fact is they didn't. They did say ordinance. And so I guess my question for you is, how did this interpretation come to be that it was only going to apply to section 6729-6 and not the entire Sunshine Ordinance?
My understanding is that this written agreement was in direct response to the actual complaint that cited that section, but our failure to disclose the amount and source of all outside funds or services worth more than $100 in aggregate. I would point out in the more expansive MOU document, we do have a section on acceptance of gifts in which the library will adhere to the city's administrative code requirements with respect to acceptance of gifts that are enforced at the time of the acceptance of the gift. So that would be a really comprehensive, I guess, catch-all statement.
I don't want to misquote Mr. Hartz, but I believe that Mr. Hartz's contention is that they need to abide by the entire Sunshine Ordinance. That is not just the sections related to gifts and things like that, but related to meetings and records and issues like that.
Sure.
What do the other members think?
That's my recollection of the meeting also, and also not only was this document requested because of the financials, but this document was requested because for years there had been no document. And there was no written agreement between the library and the Friends of the Library. So that's why this document was requested for this meeting. I would say that this document from the Friends might suffice if it said it would comply with the Sunshine Ordinance as is specified in 6729-6. It does say ordinance. It doesn't say this section of the ordinance. And
It does.
29
The last paragraph.
is because it says when such funds are provided, must agree in writing to abide by this ordinance.
Then it has a section that's about the disclosure, which is, I believe, talking about it affects the full paragraph. Am I?
Okay.
Like the disclosure is as 6729-6 is actually talking about I see what you're saying. But I mean, it does say ordinance. So I mean, is that always the case when we talk about the ordinance within the Sunshine Ordinance, that we're talking about the whole of the ordinance, or?
Well, I think they've just responded to our order of termination, which cited that particular section, and therefore they're addressing their letter to that section. But I'm not a lawyer myself, and I don't know whether this document alone will satisfy it, whether it's a combination of this and the MOU, or what more is needed. As far as where this is going to go, I think this will probably go back to the full committee in some shape or form with our recommendation. If and what we feel about it, and that's kind of what we're here to flesh out. I had a question for Mr. Hartz.
Yes.
So, what do you think of this letter, this one-page agreement?
It basically is, in my opinion, an attempt by them to limit their compliance with the ordinance. They're trying to put a document in place which says we have to comply with this section of the ordinance and release our donors. And Chair Wolf at the full hearing made it very clear to them that the reading of the ordinance was that they had to comply with the entire ordinance. And I think, unfortunately, letting them go with this, we have this other memorandum of understanding that says we're going to follow the city charter, is too vague. They need to sign an agreement that just basically says, I mean, I originally looked at that one page and says, okay, that's fine. Then I read it and I go, oh, no, they're just agreeing to abide by one section. What about the rest of the ordinance? And they need to say clearly that they are going to abide by the entire Sunshine Ordinance.
Okay. Unfortunately, going by what was written in our minutes, as you read out at the beginning of the presentation, it just specifies that particular section. So whether we want to kick it back to the full body and make it broader might be a decision for the full task force, just to capture the spirit of what you're trying to achieve.
Well, that's what I was saying, is that discussion was held before the full task force, and Chair Wolf said, no, you're not just agreeing to abide by this section, they are agreeing to abide by the ordinance in toto.
So the more I read this section, it basically says when such funds are provided or managed by an entity and not an individual, that entity, which is the Friends, must agree in writing to abide by this ordinance, not this section. The rest of that paragraph is describing what this section is, but the entity should abide by the ordinance. That's how I read it. Now, if the library and the Friends would change this letter and take out 6729-6 and put in the Sunshine Ordinance, would that satisfy you, Mr.
That would satisfy me, because they're agreeing. I don't want to get into a situation where down the road I ask for records from the Friends and the Friends say, well, that isn't part of the donation, so we don't have to give you those records.
What if it said, in compliance with the Sunshine Ordinance, particularly Section 6729-6, with that language?
Again, I think their attempt in doing this was to simply try to limit their exposure.
Okay. Well, I'd like to go back and at some point listen to the recording of that meeting and what you're saying the chair said, and I wish that had gotten more into our summary, because we focused on the narrow rather than the broad.
Well, see, that goes back to Mr. Warfield's statement about the way the agenda item was put on here. It was put on there in a way that it did make it sound like the issue was disclosing donors. And it wasn't issue of disclosing donors. I tried several times to make that clear during the hearing and so forth. The issue is the ordinance in this section says that if you're an entity raising funds on behalf of a city agency, then you are required to abide by the Sunshine Ordinance. And that's the whole Sunshine Ordinance. And I think if you just read that section, yes, it does go on to delineate the donors, but that doesn't negate anything about agreeing to abide by the Sunshine Ordinance. And simply saying vaguely, we have a memorandum of understanding that we're going to follow the law. Which law are we talking about? And then we get into arguments about that. I want it clear. They are agreeing with the library to abide by the Sunshine Ordinance. And I showed you the example, the millions of dollars that go through their hands every year, and the library gets $400,000. 10%?
Okay, make that connection as far as the Sunshine.
Well, it's like I think you may have heard about the Wounded Warriors Project recently, where they found that they were spending money on limousines and vacations and trips and all sorts of things, where the people making the donations thought the money was going to help Wounded Warriors. And it's the same thing here. It's on the library's website. Support the library. That's what it says. So when people click on that link and go to the Friends website and they sign up for a membership or they make a donation, I think the public would understand that to mean that a significant portion of the money is going to the library, whereas we're seeing now that if they give the maximum amount authorized by the Board of Supervisors each year, they're giving 10%. That means they're spending 90% on their own operation. And if I gave a bequest in my will of $10,000 to the library, I would expect a significant portion of that money would go to benefit the library, not to support the Friends.
You have the respondent again, please. Would the Friends and the library change this document to just say agreement to comply with San Francisco Sunshine Ordinance?
Well, I've made a note of that, and we can certainly take that under consideration. We've been working with the Office of the City Attorney, so this is really a legal question.
Okay, so if that's the case, can we?
Can I ask another question? Are receiving funds on hold from the Friends of the San Francisco Public Library until this matter is settled?
We currently have an annual process that goes through the Board of Supervisors. It's an accept and expend process. So the status of that is coming up. We are going to be submitting our accept and expend to the Board of Supervisors later this summer, and we do this every year. We submit a grant proposal to the Friends, they submit an award letter, and then we take that to the Board of Supervisors, as we're obligated to do, to get the board's approval. So the fiscal year 18 begins July 1. So that would be the next opportunity to accept the next cycle of Friends support.
What was that date again?
July 1 is the beginning of our next fiscal year.
Through the chair, I think we can pursue this direction, have them, look into that. But I think we should kick this back and have that order determination reworded to capture, what we're trying to get at here. Because unfortunately, I think it came out of the sausage maker too narrow, and it's going to miss the point.
Okay, so you're suggesting sending it back to the full task force?
I think so. I think because I'm not sure we can change an order determination, can we?
We would need to send it back to the full task force, but I would suggest that we amend the title at this time to reflect the true intention of the complainant, and then send it back to the... I am speaking to the microphone. I would suggest that we send it back to the full task force, but make an amendment to the title prior to sending it back to reflect the true request of the complainant.
Member Moss?
I mean, I'm not sure I understand what that means.
Well, I believe that the way the title is currently written doesn't reflect the request of the complainant.
Right. Which title? When you
the
say
title that's on the agenda
is too narrow. And unfortunately, that's coming right out of our order determination, correct?
Yes.
So in order to change that order determination, we have to go back, take it back to the task force, have the Chair Kanata present why we're doing this, give a summary, and explain that, what came out was not the intent of what we... Well, I mean, either we made a clerical error or, we didn't summarize it correctly to get to this point.
Yeah, I think for me, I mean, I feel like the agenda item is inappropriately. It does not describe what we're getting to, but I don't know that the order of determination has that same problem. The order of determination is fairly broad in the way that it's
Really? Because it's
written.
pretty specific too, isn't it?
So when I look at it, I'm seeing maybe we're looking at two different things. So the order of determination is Vice Chair Highland, seconded by, am I looking at the right thing?
Yeah.
Okay. Seconded by Member Kanata, moved to find that City Librarian Louis Herrera and the Public Library violated Administrative Code Section 6729.6 by failing to maintain a written agreement to abide by the Sunshine Ordinance. That's the part.
Okay.
And then it says, with entities collecting / maintaining funds for purpose of carrying out or assisting any city's function, unless the amount of source of all such funds is disclosed to the public record. All that second stuff, I think, is just kind of extraneous clause stuff from the language, as I understand. I mean, my reading is that it ends. I mean, the issue is that the agreement needs to be abide by the Sunshine Ordinance, and then if you look below what's referred to us, it just simply says we need to review the draft MOU to make sure that this 6729.6 issue is addressed, and it's not doesn't go into much more.
Fair enough. I mean, the actual violation could be 29.6, but the remedy is something broader than that.
Yes, that's I think the issue that we're looking at.
Okay.
Like, I don't think that at any point we said that the solution. Now, they may feel, and the city attorney may argue that they're interpreting the ordinance differently than we are.
So what it's, if it had just said the task force refer the matter to the Compliance Amendments Committee to review to ensure that the Administrative Code Sunshine Ordinance is addressed, and just strike 6729.6 reference in there. We already used that to find the violation, but this letter and this MOU needs to be broader to address
Right.
the entire code.
Could you read that again? We did ask for.
Can we do that
We
at
did
this
ask
committee
for a
level?
draft of the MOU.
So the ask that was made from the task force to this committee is the task force referred the matter to the Compliance and Amendments Committee to review the draft memorandum of understanding,
Which we still don't have.
which that's this.
No, it's not.
So this is an agreement.
This is just a letter. This is just a letter from the Friends regarding
Okay.
29.6.
So draft MOU. So there is a draft MOU in this document in our packet on page 226.
So
And then I guess this is an addendum to the MOU, or is this incorporated into the MOU?
That is a separate written agreement. The MOU between the San Francisco Public Library and the Friends is intended to be the more comprehensive agreement.
Well, so that just makes it more clear that we can just, I mean, I feel like I can say that this is not in compliance because the document we're looking at is not an MOU. It only has one set of signatures on it.
Right.
It's not drafted to have two sets of signatures on it.
So I think we can continue this at committee level, because we're not changing the OD, and we just make the instructions a little clearer.
Yes.
I think we're good with that.
I'm fine with that.
And I can clarify the title for the next agenda.
Yeah.
Okay.
And at some point, do we need to have the Friends of the San Francisco Public Library be an actual, I don't know, a full part, not a party to the complaint, so to speak? But
I'm not
a
sure
party
we
in
can.
these
I don't
hearings?
know if they fall within our purview. Therefore, I'm not sure they need.
I mean,
to
they
be
signed
here.
a document here saying that they're part of our purview.
Yeah, I mean, but it's up to the library to bring them into compliance, not us.
Sure.
I
Okay.
believe.
Yes. Pursuant to 12L.
Right, 12L. So,
So,
I
we
think
have-
We're going to
Do we
continue
have a-
this,
do we
I
have a
guess.
motion?
A motion to continue to the next meeting.
I will say though, I think in this case, mea culpa in our language. However, by the next time this subcommittee meets, if we don't see an MOU, then we're going to be approaching 6734 issues because we've put this off quite a long time. So, you're going to have 1 to 2 months to
Month and a half.
to comply with this corrected title and directive. Is that fair?
Thank you for that guidance. Would it be possible to address this matter and conclude it at the next full task force meeting, or does it still need to come back to this committee?
I think we can probably handle it at the committee level, just because now that we've got to the root of it. And Mr. Hartz, would you have anything to say on that? Are you in agreement that we're more on track now?
Yes. Basically, the intent from the filing of the original complaint was always that section requires them, and raising money for a city agency, to agree to comply by the Sunshine Ordinance.
Okay.
And the fact that second section in there has thrown a kind of monkey wrench into the works. But the bottom line is they need to agree to abide by the entire Sunshine Ordinance.
Gotcha.
They're raising millions of dollars a year in the name of the library.
Okay.
And also to be clear, the ordinance does not require an MOU. That was in our order of determination. An agreement would suffice for 6729.6.
Well, I think we referenced MOU because it was brought up by the respondent.
Yeah.
And they said it was in the works. It's in the works. We're like, okay, let's see it. And instead, they've produced this one-page document, which I think we want to see the MOU because that's what we're after in the OD. Mm-hmm. If they can, in addition, produce this second document if they want to. Mr. Hartz?
I have a copy of the MOU, and I believe it's in your packet, but it's just a vague agreement, and there's nothing in here about the Sunshine Ordinance. It's just, Mr. Lambert is trying to say, well, because we agree to abide by the city charter, that automatically includes.
Right, let me correct that. So your final MOU that does put you in compliance with the ordinance is what we're after.
So one reason perhaps to send this to the full task force is that we will not be meeting again until after the next fiscal year deadline for the library. And so there is a risk that they move forward with a whole year's worth of funding based off of this document that we may or may not deem to be compliant.
When is that date?
July 1st is what they had said, and we won't meet until July, second weekend. First. It won't be July 1st.
May I ask? Does the MOU depend on the fiscal year?
July 10th is when we
depend on the fiscal year, or is that considered separately?
That's considered separately.
Okay.
I'd say that book is that year is in the books anyway. I mean, at this point, I would rather, as far as mechanics, reserve sending it back to the full task force if we're not satisfied with the MOU, or if we start to approach 6734 issues, just as a to try and take care of it in subcommittee. That's just my thought. But
one further question I had about this, and maybe if they're coming back, they can address this in the next draft, is that it leaves very vague the retroactivity of records. There are many years in which an agreement like this, even if the interpretation is as narrow in this document, then there are many years in which documents, this information should have been available to the public. And so I would like to see that issue addressed so we can at least evaluate how it's addressed next time you're here.
Duly noted.
Okay, so do we have a motion?
So motion to continue to the next.
Right, with the... Victor, do you want to summarize?
The motion is continuing matter to the next meeting of the Compliance and Amendments Committee, estimated to be July the 10th, 2017, with instructions to the public library to work on providing a draft MOU that...
Final draft? Or?
Well, final MOU is not final until it's signed by both parties, so...
Okay.
So to present an
MOU and an agreement if they wish to.
Just an MOU.
To produce the MOU to state that the nonprofit organization in question shall abide by the entirety of the Sunshine Ordinance.
That's good. And then you're going to change the title.
And I will amend the title to reflect that.
Okay.
And there are additional questions from the task force, but that is not part of the motion.
Okay. So do we have a second?
Second.
Okay. Public comment.
Good afternoon, Sunshine Ordinance Task Force. Once again, Louis Dillon from Making San Francisco Great Again Coalition. In this item number 6, clearly the collateral damage that's being done by allowing continual fundraising and funds to be directed towards the city librarian without the public knowing where these funds are coming from creates a lot of collateral damage in the city. Basically, it allows the library to operate autonomously, to not be held accountable, and to be able to flaunt the laws and just say, well, we'll get our money somewhere else if you don't like it. And these are the results when government fails to police and stop these sort of robberies from continuing. And that's what we're seeing here in San Francisco, is the robbery, public's right
Not holding the microphone?
to information. And when you drop the ball, that's what the collateral damage results in. Clearly, for some reason, these institutions are just able to blow people off and say, well, if they need the information, let them go to the Sunshine Ordinance Task Force and get it. And then they know, once a complaint has been filed, that they can make X, Y, and Z excuses for why they didn't provide the information, and then X, Y, and Z reasons and delays for complying with it. And this is the revolving door of San Francisco politics, or corruption, however you want to look at it. And that's why when I look at the agenda and I see in this item, at the bottom of item number 6, it goes on to talk about item number 7. The paragraph is totally in the wrong place. So these signs tell me that you're really not on the ball. You're dropping the ball. It's just a charade. Get on the ball, do your job, and stop letting these robbers rip us off.
Any other public comment?
Peter Warfield, Executive Director of Library Users Association. First of all, thank you very much, Chair Kanata and Member Moss, for, I think, mainly getting it. And let me say this, I do not support this motion to drag this out at the committee level. The library has not gotten an agreement from the Friends to comply with the Sunshine Ordinance. It is neither in their MOU nor in their one-page document. Now, let me say that I think an MOU is a complete red herring. In this MOU, there's basically a certain measure of hostile takeover of control over library resources. Mr. Hartz has pointed some of these out that they already are doing anyway. And your commenting on an MOU, I think, is not appropriate because the library and the Friends are going to say, oh, they approved our MOU. No. You're not in the business of approving a takeover or the conditions of how they use the names and sell things. You're here to see that they complied, and they did not. Neither in the MOU, and in fact, there are things in the MOU that violate the Sunshine Ordinance. Now, let me say this. The complaint was clear. The library's response was to your formulation of the complaint, which was completely wrong and on the wrong track. If I give $250 to the library or over $100, it has to be posted with my name. In any given year, the total has to be posted on the website. And you can see that as an example on your page 199. However, if I give the same $250 to the Friends, no name is attached. And that in other places is called money laundering. In other realms, that's what it is. We have many laws, campaign finance laws, sunshine donor posting laws. And the reason is we want to see who is the source of funds and possibly who's trying to influence what the library is doing. The Friends are not providing that information. And the twists and turns, I believe, are going to prevent exactly what especially the two of you said. Their donor lists should be open to the public. Their meetings should be open to the public. And in every other way, they should comply with the Sunshine Ordinance. I think this needs to go to the full task force. And unfortunately, I think the accept clause in the order of determination is wrong-headed. They don't get to go outside the sunshine if they post certain information. They unconditionally have to comply, and I think if you want to correct or improve the wording, then Member Hyland's suggestion to go back to the sunshine full task force to do that is appropriate, but you have gotten no adequate response today, and that should be something that the Sunshine Ordinance takes up, as well as possibly the faulty, I think, wording where the order has an exception, it seems. If they post, then they don't have to comply with sunshine. That's what it seems to say. But in any case, they haven't complied today, now, at all. Thank you.
Any other public comment? Seeing none, let's vote.
On the motion, Member Hyland.
Aye.
Hyland, aye. Member Moss.
Aye.
Moss, aye. Chair Kanada.
Aye.
Kanada, aye. The motion passes.
Okay, next item, please.
Next on the agenda, item number 7, file number 17047, complaint filed by Angela Grebin against President Ludden Breed, Board of Supervisors for allegedly violating Administrative Code, Section 67.21, by failing to respond to requests for public records in a timely and/or complete manner.
I would like to recuse myself from this one. Ms. Grebin has, and I have interacted professionally through EFF, as well as some of my colleagues, and I do not think it is appropriate for me to hear this case.
Okay, do we need to vote on this?
There's
or-
no need to vote.
Okay.
It is at discretion of the member if they would like to,
Okay, fine.
recuse himself. If you'd like to be cautious, you can take a motion to excuse Member Moss from this matter.
But it's not necessary, right?
I believe we probably should take that motion.
Okay.
Based on precedents of other bodies, we should take a motion to recuse.
Motion so moved.
Second.
You could, you could second.
I second, I guess. Yeah, whatever.
You vote on
Actually, you
vote on
cannot
it.
vote on,
Okay.
on
I can't
his
vote
own
on-
matter.
Okay, so public comment.
Public comment on the motion,
To recuse.
recuse. Seeing none. Take it by-
The motion to pass the motion. Member Hyland.
Aye.
Hyland, aye. Moss excused. Chair Kanada.
Aye.
Kanada,
Aye.
aye. Sorry. The motion passes. Member Moss has recused himself from this matter.
I'm going to go take a break for a little bit.
Okay. Is the complainant here? So don't recuse yourself yet. Nobody's here. Yeah. Okay. Is anybody here from Supervisor Breed's office? So we have nobody here.
Is this a new case?
This is a brand new case.
This is
yes.
new. I had some questions on it. It seems to me the case is about blocking individuals from Twitter accounts where Supervisor Breed is making city.
Before we get into
Cut.
that, maybe we should determine jurisdiction, at least get that taken care of.
Okay.
And then we can package and decide
Sure.
what we want to do with it.
Okay, so
Motion to find jurisdiction.
second. Any public comment on the motion for jurisdiction? Seeing none, can we take it by acclamation?
So moved.
Okay. So, I mean, my reading of this is that the complaint was because Supervisor Breed was blocking individuals from her social media, specifically Twitter. There was Facebook mentioned also, where these Twitter accounts and other social media was being used to conduct city business. The request went to her, and I think all the supervisors. The complaint is against Supervisor Breed, but I had questions about some supervisors answered her request and others haven't. So I wanted to get more information on what was going on. And she also sent the request to Supervisor Breed's email and got an auto response and then never heard anything else. So I don't know, you know.
This is, I think, City of San Jose versus Superior Court is going to have a lot to weigh in on this. I think that's something as a full task force we're educating ourselves on. I think we should just bump this up to the full task force with, no recommendation, and perhaps even package it with the other Twitter item that is pending.
Yes, that's scheduled for June 7th.
Yeah, my only concern with doing that right now is that one of the purposes of us hearing the complaints here is to try to get all the facts before sending it up. And with nobody here, there's no way for us to determine what the case is really about.
Mm-hmm.
So,
does the other case, does that involve the same individual?
It's against the same respondent, different individual.
Okay.
But the same issues. I believe it's more of a failure to respond. Taking Twitter out of the equation.
Okay.
It is a failure to respond to a request for public records.
And has there been any subcommittee level activity on that one?
This is the first time this has been heard.
So that's the first time as well.
Today.
No, the one that's is already scheduled for June 7th.
That was heard by one of the committees. It was referred up to the full task force for hearing.
Okay. Was anyone present at that one?
The respondent was present.
Was present?
Actually, no. The complainant was present, but the respondent was not present.
So it's consistent.
yeah. I know we were discussing this. I don't know if it ever got voted on, but we were discussing having the respondent mandatory be at these
right.
meetings.
It is mandatory for them to be at these meetings at this time.
At the subcommittee level, but not at the full.
They're required to be at both meetings.
But they're not here.
Yeah, I think we discussed and passed that.
Right.
And that's reflected in the language. I think that Victor, you send to respondents at this
I do require
date.
both the parties to be present at both meetings.
So they're ignoring us.
Okay, so we should note that.
Yeah.
I think that should be noted as part of what we send up.
Yeah.
And I don't see what else we can do at this point.
Yeah, because I think if we put it off, it'll just linger and linger. So let's do that. So
with recommendation for 67. We could recommend a violation of not sending someone knowledgeable to the proceedings, because this is technically the second time that office has not sent us somebody. I mean, if you wanted to get technical, or
let's just send it up without any.
Right.
I would suggest sending it up without any recommendations.
Fair enough.
And we will note that there was no presence of the parties.
There was no presence here. Correct.
Yeah.
So the motion is to send this to the full task force without recommendation, with noting that neither party was here.
Second that motion.
Is there any
public comment on the motion? Seeing none.
On that motion, Member Highland.
Aye.
Highland, aye. Moss, excuse. Member Chair Kanata.
Aye.
Kanata, aye. The motion
All right,
passed.
Member Moss, come on back.
Yeah. A short reprise.
There was no public comment. We did request.
Could he have said anything under public comment at that point? Since he was a member of the public at that point?
I think there's a certain extent I can speak to the public.
All right.
Next on the agenda is item number 8, file number 17059, hearing regarding the citywide drone policy and its compliance with the Sunshine Ordinance. I did make a request to COIT to send a representative. Their person was not able to attend today's meeting, and there are questions regarding his ability to answer the questions that the task force is asking, and to submit specific questions to COIT so they can gather the correct people. There are potentials for rescheduling this before EOTC time permitting, but nothing has been set yet at this point. I believe that Member Moss would have more information on this.
So we have this IT ad hoc committee that we've been meeting, and during the further announcements agenda item section, I had said that I thought it was worth us looking at this drone policy that COIT has passed. And originally we had said we should send it to this committee, but it doesn't look like they could send somebody to be at this committee, and I didn't necessarily want to wait another 2 months on this, because this policy that we are looking at, as I understand it, is the model policy for COIT, but that each individual agency listed on here has to come up with its own policies that work with these policies. And I thought that it was important for us to start looking at this now so that all these other departments don't start writing policies and then we have to, criticize 5 policies instead of criticizing the one. The issue that I think is worth us looking at is regarding what happens to raw footage. And I'm trying to figure out, if you give me just a second, I can bring up where it has that in there. So it's a short document if you want to skim through it. But there's various places in here in which it says that raw footage will never be released to the public. And by raw, it means footage that the PII has not been scraped from all of the footage. And I am not sure I'm not sure that's consistent with the Sunshine Ordinance. So let's see. Trying to find the exact words.
424 under security, is that what, page 424?
424.
Under the data security, departments are advised not to maintain archives of raw and processed data.
Distribution of raw drone data is restricted to authorized departments. In all other circumstances, the city may not exchange raw, unprocessed drone data between departments or disclose such data to the public, except for exigent public safety needs or as required by law. So the way they imagine this is that these are not law enforcement drones. None of these are law enforcement drones. So there's no law enforcement exception that they would be able to claim. So it's fire department, public utilities, port, recreations, and parks. So let's say the port is shooting video with a drone just over the beach. That footage would not be available to the public until such point as they redacted the faces of every single person who appeared in that image. I don't know if that is if that actually works with the Sunshine Ordinance or not. And I'm not necessarily sure how to proceed about this, but I thought it was worth discussing, and Bruce thought it would be good, and Chair Wolf thought it would be good for this committee.
Yeah, I saw that, and I had questions on that, very similar questions on the fact that they're collecting all this data, but the data in and of itself isn't available to the public. And I know if we ask for, if a citizen asks for a public record, and not all of it is disclosable, they will redact it and give whatever is disclosable. To me, it would seem it would be the same concept here. But then, how do you determine? In your example, you're going over the beach and you have footage of, 20 people. How do you determine what's redactable at that point?
And is any of it redactable if they've shot it in a public place? That's the question here.
Yeah.
But I'm not even necessarily sure. I mean, so it's a very good question of who we would need to ask about this. I think that the director of COIT probably is not an expert on the Sunshine Ordinance. I do not know who the attorney is in the city attorney's office who signed off on this, or if they would even be able to speak to us in that capacity. This committee has some really top-level executives in government sitting on it, and I'm not sure if they should be the ones, if the chair of that committee. I mean, if the Sunshine Task Force had passed a policy that was objectionable to the Ethics Commission, would Victor have to come in, or would Bruce, or would Chairman Wolf? I imagine Chair Wolf would, and not Victor. And as I understand it, the role of the person we initially asked is closer to your role than it is necessarily Chairman Wolf's role. Is that right or wrong, or am I totally off base?
I would be guessing, but it sounds correct.
So I think that maybe it's the chair, who is the city administrator, might be the right person. But I don't know whether we should just kick this over to EOTC just for the sake of time.
Well, I think if the only reason to kick it over is if we have a commitment by somebody to be there.
Right.
Right?
And I believe a large part of that would be asking our questions and asking them to provide parties who can address the questions that we have.
Yeah, but to me, that's a start, because once you start, if you have somebody who's knowledgeable and you start a discussion, you're going to have questions that you might not have just by reading the document also.
Yeah.
But
I mean, like, it seems pretty clear to me. I mean, the questions, I mean, I don't want to write out a list of questions when really whatever question we ask is going to have us ask 5 more questions. Like, I don't want to anticipate every possible one. And every time an agency has asked me to do this, I've sat down and I've written out 10 questions, and I get answers to maybe 3 of them. I think the issue here is we need somebody who can address the issue of raw data and the Sunshine Ordinance. And that is, if whoever comes to talk to us just needs to be able to address that limited area.
The city attorney also.
Yeah, the city attorney?
Because the person in charge of this may have their concept of raw data and how public it is.
Mm-hmm. I mean, is it against the Sunshine Ordinance to write a policy that's against the Sunshine Ordinance, or do you actually have to do something?
I think it's the verb, not the noun.
What's that?
It's the verb, right? That it's doing something that violates the ordinance.
Right. So I mean, basically, we have a policy that if it's obeyed, this policy is obeyed, that the act of obeyance may be a violation of the Sunshine Task Force, but we would also probably have to see a complaint over that first. Does that sound about right? How it would have to happen, or could we initiate something?
Wow.
I don't know.
I don't know either. So
Member Highland has the most institutional memory here, so I'm kind of like looking over at him.
Yeah, I'm not sure about this one.
So while you're thinking, what does anyone know what the status of police? I know police is a different matter with ongoing and things like that, but their cams when they record.
The body cams. Yeah.
Is that public data?
Actually, why don't we take a little public comment on this since we're talking? If anyone wants to weigh in.
Yeah.
They're
any public comment here?
There we go.
Mr. Hartz.
We can
I knew
always have something to say.
I knew he couldn't resist.
I think in response to your question, Mr. Kanata, the body cam images of the police incidents or so forth are public records. However, they are subject to the fact that they're under investigation and may not or cannot be disclosed because it might interfere with the investigation or give out information or whatever. So Whether or not and I think you're also right on the doing, the verb versus the noun. I can write a law about anything, but until that law is actually broken, there's really no cause for action. It's like in a court. You're saying, well, I'm going to go in and sue on the matter of the immigration policy of the Trump administration. The court's, if I said that, the court's going to laugh at me and says, well, how does it affect you? And my answer would have to be, it doesn't affect me. And unless I could show some way it did affect me, I wouldn't have any standing and couldn't bring the case. And it's the same thing with the complaint. Once the law is written, then somebody has to actually act upon it. And when they act upon it, then somebody else has to say that that was in violation of the law and bring the case. So it's cart before the horse and all that kind of stuff. But the drone policy, I don't know. It's going to be, I think, just about the same as the police commission arguing for years over training people in non-violent techniques for dealing with the homeless and so forth. It was kind of ironic that just recently I was sitting in a police commission meeting, and they were talking about training officers with the non-lethal techniques, and it was kind of bizarre because I seem to remember having them having talked about it before, and it was at the very first police commission meeting I went in 2008. They were talking about the same thing. So basically, they kind of go round and around in circles. And if you look at the actual general orders that the police follow, I feel sorry for the police, because basically they have general orders that have been in revision for 12 years, 14 years. So if you're an officer and you're out there trying to do your job and follow the departmental directives, you're not ever at any point exactly sure which version of the departmental records you're trying to follow with and what you're trying to comply with. And I've said that to the police commission. I said, it's just a matter of fairness to your officers that you can't let these general orders drag out for years, because it puts your officers in the position of not knowing exactly what it is they're supposed to or not supposed to do.
Any other public comment? Drone policies. Okay, seeing none. When is the EOT?
That'd be June the 20th.
And then ours is July
10th.
I mean, I'm happy to kick this for EOTC to deal with it. I imagine in the end what's going to result is a letter from the task force letting them know that they're setting themselves up for complaints. That's what I imagine.
So who would we ask?
May I suggest Member Moss provided that brief statement about the subject matter, that maybe we can just say we want someone to come who can address the specific subject matter in detail, and let them decide who to send.
Great.
And if
and don't limit it to one person. Say we would like people, or we would like representatives.
All aspects of this subject matter.
Yeah.
And if I hate to ask you to repeat it, but
so we are looking at how the Sunshine Ordinance. Let me back up. So we're just thinking through my head. We're talking about the issues of raw data. The issues of raw data and access to records under the Sunshine Ordinance.
Mm-hmm. And do we want to also include the fact that departments can add their own rules on top of these?
They're supposed to pass their own rules on top of those. I think we'll have to call on each of those agencies separately, all 4 or 5 of these. The controller, the fire department, the public utility, the recreations and parks. But hopefully if we can talk to Coit first, we can head off some of that.
Mm-hmm. Okay. All right.
Does that make sense?
So we're...
I will, if I have issues with that, I will discuss it.
Yeah. Okay.
And we'd have a complaint ahead of us already if the library had put in for a drone.
So is that what is this the motion?
I believe we can continue this matter to the call of the chair, and if EOTC is able to pick it up, we will schedule it there. If they are not, we'll bring it back
Okay.
to compliance amendments on July the 10th.
That's great.
I'll work with the Chair Josh Wolf regarding his agenda to see
Okay.
if they have time.
Great.
And you could also ask. I mean, if I time willing, I can probably come to that committee as well.
Yes.
So yes, so moved, I guess.
Okay.
Who is making that motion?
I'll make it.
Member Moss.
I'll second it.
We've already taken public comment.
Yep.
On that motion, Member Highland.
Aye.
Highland, aye. Member Moss.
Aye.
Moss, aye. Chair Kanata.
Aye.
Kanata, aye. The motion passes. Next on the agenda, item number 9, announcements, comments, questions, future agenda items, and pending calendar by members of the committee.
What is this hearing thing on?
This is a subject matter that was heard. I believe there was a request by a member of the task force for this committee to hold a hearing regarding this matter and to
Yeah, this
policy.
this was the complaint against the planning department when they held a joint meeting with Park and Rec, and they only allowed they were voting on an EIR, and then they were voting on the project, and they only allowed public comment one time. And we found violation, and it went up to the committee, and the committee found violation.
I don't believe it. I believe the task force found a violation. It was not sent to committee.
No,
the committee heard it.
Yes,
they went to the full task force.
Right, they found violation.
They found violation, and at that point, the matter was concluded.
Right.
And it was
But
was suggested that if we want to look into writing a letter as a memo to all departments with suggestions as to how we believe recommendations to city departments on how joint meetings should be operated. I believe that's the point of any future hearings.
I'll try to write something up and send it to you. I think my feeling on that matter, and I think what the full task force, and that was the meeting I missed, what the full task force felt was that even though you have one project, if you're having two different votes, you should have public comment for each item.
And I think in addition to that, we should also address how each of the agendas should look, in that if it's going to be a joint meeting, the agenda should match from both sides of the equation.
Right, because you can have a project and two different departments are doing different things in that project, even though they might be on the same, topic. But basically, it's just a reminder to departments that if you...
And I will attempt to... I believe there may be information regarding standards from other organizations who have joint meetings.
Okay.
If we can possibly take a look at some other samples.
Yeah, some templates would be nice.
Templates and see how other organizations operate when they do joint meetings. And then maybe develop a recommendation memo for all departments to deal with this.
All right. I'll try to write something general about the joint meetings, the agendas, the public comment.
Yes.
Just a reminder on joint meetings from the SOTF, something like that.
Yeah.
Yeah.
Yes.
Yeah. Okay. And good.
Member Moss? No other announcements?
No, not for this one. I have other committees now with which to drop my last minute announcements or requests for agendas.
Right.
Public comment.
Any public comment on the item number 9? No. Okay.
We're returning to our.
Too slow. I've never seen it move so fast.
Did I hear public comment?
You did.
Wait, before he goes.
I heard item 9.
Our next meeting is back to its regular schedule, is that correct?
Yes.
I believe the next meeting would be...
I couldn't
July
make the
10th.
regular scheduled one, and we couldn't get a fill-in, so we bumped it out.
I believe the next meeting would be July the 10th.
Yeah. Okay. Public comment.
Public comment on item 9. Thank you for your public comment. Next talker.
I
Thank
would
you.
like to protest the intrusion of non-chair persons on what should be the prerogative of the chair. I did want to note that one of the provisions of the 11-page MOU that doesn't have what you asked for, namely compliance with Sunshine, says neither party may record this MOU or any memorandum hereof. I don't know what that means, except what? They're not going to make an audio recording. They're not going to make a piece of paper. They're not going to give me a copy if I ask for it. I'm concerned about, as I said, that the MOU is a red herring. It's got nothing to do with the Sunshine Ordinance. It's full of things.
Mr. Warfield, I'm sorry. Point of order, and I don't have to go to the chair for point of order. This is on item number 9.
You have to address the chair, and the chair has to make a ruling.
Point of order can be a point of order, and this is item number 9. It sounds like you have a lot to say on this item. If you want to send it to Victor, we can include it in the package. If you want to, he'll forward it to us.
Thanks for the lecture.
Well, you're welcome.
I have something to say about
you know better.
9.
Okay, thank you.
Oh, I know better. Thank you. Thank you, Teach.
Boy, somebody got out of the wrong business I did this morning.
What's that?
Carry on.
The hostility of one of your members is pretty toxic. Today and at other times. This is the member who said one of our complaints was duplicative of other complaints, and that kept us from having a complaint for a year. And then when it finally turned out that it wasn't, there was no apology, there was no noting of what happened. That was it. What I wanted to say about item 9 is to thank Member Moss for the excellent request for information, and to ask that you put the response of the library and the response of the city attorney on a future, preferably soon, agenda. It seems to me that looking at the responses of the city attorney to your information request is completely inadequate in a number of instances, particularly where the request asks not for compliance with Sunshine, but for information about correspondence between the library and the Friends at several points. And yet I saw responses in here that said we have an exemption based on attorney-client privilege or something else. And I don't think that correspondence between Friends and the library is protected by attorney-client privilege. So I would be very interested in seeing publicly all of the responses that they gave to your request, and I would be interested in the task force pursuing whether the responses were adequate. And I think that should go on an agenda coming up soon. Thanks very much.
Any other comments? Seeing none, Victor, can we adjourn?
Would someone like to make a motion to adjourn?
Motion to adjourn.
Second.
By rise in acclamation,
Yep.
the meeting is adjourned.
What was that comment?
I forget.